Your next speaker, Carlin Burton, is the one who teaches the Patent Academy. So while it is an online program, Carlin actually has 3 modules that she kind of walks you through and really brings it to life and can answer questions. She's just done a remarkable job. We've had about 200 students that have gone, 200 small businesses and students that have gone through the program. It's really been amazing. So Carlin is a partner in OSHA Bergman, Waterby, and Burton LLP, an international intellectual property boutique law firm headquartered right here in Houston, Texas. She's led our Patent Academy, and she provides incredible instruction in all of the complexities of the patent process. She has a bachelor's and a master's degree in chemistry, which you'll find out why that's really important, from Emory University, and her law degree is from the University of Houston Law Center. So I really appreciate all of the instruction that you have done, and she has actually helped to put today's conference together. So thank you, Carlin, and it's my great pleasure to introduce her.
Good morning, everybody. So as Maya said, my name is Carlin Burton, and I am a IP attorney here in Houston. Most of my work is in patent law, but I do some work in trademark and copyright and trade secrets as well. I have volunteered with HCC in some capacities and was introduced to Maya through the entrepreneurship program. And she, has explained to me that there was this idea, there was this Inventors Patent Academy, which is this really in-depth online course. But there was an opportunity to, how to make that real, right? If you take the course, you might have questions, and you can't ask the computer screen your question. So I said, well, I'm happy to, because anything that can help, right, drive HCC student success, I'm interested. Anything that can help Houston startups, entrepreneurs, right, be successful in their endeavors, I'm in. I'm very passionate about talking about intellectual property, not just in a room of lawyers, but also to people who see this as a complex system and they don't know where to start. So the Inventors Patent Academy, I highly encourage you to go online and take the course. The workshops that I teach with HCC, it's broken down. It mirrors the modules. You'll see slides, the content that's coming through, and then that helps you think of the questions that you had when taking the course. Any question you have that comes up, right, I'm there and I'm able to answer those. We primarily have done them online. So, right, Houston's giant, who wants to fight traffic, but we can all come together on Zoom and get through this content because it's dense material, right? I mean, those of us who work in intellectual property law, this is our job. We've gone to school, not just and gotten science and engineering or if in patent law or in if you're working in trademarks or copyrights, it doesn't require science or engineering, but then law school, right? The law is dense. So we want everybody to understand if you are trying to work within this system and take advantage and obtain intellectual property rights, we want you to understand what you're doing, what questions to ask as you go through the process. So I highly encourage you to do that, and then also join our online workshops so that you can get more information. So today, I really want to talk about kind of why IP. Why does it matter that we protect intellectual property? And not just patents, right? Patents are one form of intellectual property, as was mentioned, but it's not the only form of intellectual property. So what are the types of intellectual property that exist? We have patents. What do patents do? They protect your inventions, right? The way something works, the way it might look from a design standpoint can be protected through a design patent. And there's a third type of patent that is a plant patent if you happen to have invented a new plant type of plant. But the vast majority of patents that are granted are called utility patents, and it's really talking about how things work, right? Sarah talked about all of this evolution on communication. Those are all useful inventions, and so they're protected by utility patents. The patent, what does it do? It gives you the ability to stop somebody else from practicing your invention for a limited period of time. That time is generally 20 years from your first filing, slightly different if it's design. And the reason that we do this is that when you apply for a patent, you do have to tell everybody how your invention works. And that is what lets, one, everybody benefits at the end of the patent, but that helps inform everybody, right? Our knowledge base is growing. You can look at the patent works from others and learn from it, learn how they're solving a problem, learn how you might want to solve your problem. So it's a wealth of information that's contained in patents. But they're not the only type of intellectual property that exists. We also have trademarks. Trademarks protect the brand. So when we talk about Qualcomm, right, we know that if we're the technology that Qualcomm delivers, that it has the quality that we expect from Qualcomm. If we're drinking a soda, you know that if you pick up a Coca-Cola, that it's not the same cola as what's in a Pepsi bottle, right? So a trademark indicates that brand. The Patent Academy has some content on trademarks, copyrights, trade secrets. Part of my goal today and talking with Maya was to also give some deeper dive into those other forms of intellectual property, because it's not just patents. All of these forms of intellectual property work together, right, to support a business, right, whether they're bringing a product or a service to the market. And so the trademarks are protecting that element of the brand. Who you are getting when you see a name, who is providing that product, that service, and that you know the quality that you're obtaining. We also have trade dress, which is the way something looks. So if I showed you a glass bottle of a particular shape, you might be able to know that in fact it's a Coca-Cola that's contained in that bottle. Because Coca-Cola has also looked at and protecting the shape of their bottle, the dress of their product, okay? That's extremely valuable, because if you're in a store and you can't even, you just grab it based on that site element, right? So that's another form of intellectual property that exists. Copyright. Copyright is intended to protect the creative works, the artistic works, whether it's, a book, a song, software is also creative. So anything that is artistic and fixed basically in a particular form can be protected by copyright. You can register your copyright, but the copyright actually exists whether or not you go through the registration process. So if anybody's doodled something on their notepad, you've perhaps created an artistic work and you have the copyright in that. So you own these rights when you create them. Some of the rights you do have to go through the legal process, the patenting process, to protect your invention. Others, like copyright, that exists whether or not you go through the process. But there are advantages in some instances to go through to register the copyright. Justin, who you're going to hear from later on, is going to talk about copyright protection. Patents, trademark, trade dress, copyright, I have them on the outside of this. They're what we kind of call public forms of intellectual property, right? You do announce to the public that you have this intellectual property right? It's required, if you're going to obtain a patent, that you present and describe the invention, and then you go through the process, and it will publish with all the information about your invention. If you are using a trademark, in fact, you have to show use of your mark to get that registration. Shirazi is going to talk in more detail about the trademark system. Trade dress, same thing. You can obtain a registration for the trade dress by publicly, claiming it, so to speak, filing for that registration on a trade dress. And then copyright, we all see the C with the circle, but there is also a registration process through the Library of Congress they can use. The last form of intellectual property here is trade secret. I showed it in the middle of this, and that's because this, by its nature, is something that you hold as a secret. Its value is based on its secrecy. You're not wanting to publicly tell everybody what your trade secret is. We know that there are trade secrets that exist, for example. We know that Coca-Cola holds their recipe as a trade secret, but they are not going to tell anybody what that is because the value is based on the secrecy. Patents have a limited life, right? The patent right exists for a defined period of time. Trade secrets, on the other hand, is a right that you can hold indefinitely as long as you take reasonable steps to keep it a secret. And so there are some types of inventions that companies actually decide to keep as a secret. They might not know if somebody else is making and using the same process. And if they can't detect that somebody is actually infringing on their right, it might not make sense to publicly describe it because they can hold that right longer if they hold it as a trade secret. So oftentimes, there is overlap between trade secret and patent, but it's not only things that can be patented that might be held as a trade secret as an alternative. There's other types of information that is extremely helpful to a business, right? You have a customer list that you have worked and developed, this list, and this gives you a competitive advantage to have this information that you have worked really hard to put together. As long as you take steps to hold that secret, that can be a trade secret. You could not probably get a patent on that list, right? One thing about trade secrets is there is, I would say, the most rampant type of intellectual property infringement is probably trade secret misappropriation. And it's employees who walk out of the doors, from their employer with those trade secrets. And can be really hard to show that. So there's a lot that's going on if you are looking to set up a business, what you do and how you protect your information, not just from competitors, but also to ensure that you don't have an employee who walks out with really like your company's crown jewels. Because it can be tough to demonstrate that. But once the secret is out, once it's been misappropriated, you can't put it back together. Now, if somebody reverse engineers the Coca-Cola recipe without any sort of inappropriate conduct, it's in the public, they've done it. There's nothing that a trade secret holder can do in that instance. They took reasonable steps to keep it secret, but somebody reverse engineer it. So that's the kind of counterbalance to the weakness of a trade secret is if somebody can reverse engineer it, trade secret might not be the best path. Now, there are these 5 different types of intellectual property, but I think what makes IP kind of confusing sometimes is there are different areas of rights. However, when we think of a product, a service, they can be protected by all of them, right? There can be parts of it that are protected by a patent. There can be a product name that's protected by a trade secret. There can be the packaging, the way that it looks, that's protected by a trade dress. There can be something associated, whether it's on packaging, maybe it's software code that could be protected by a copyright. And there could be components within it. Maybe there is some unique manufacturing, or if we think about actually Coca-Cola, right? The soda itself, that is highly valuable trade secret. But Coca-Cola has also protected through patents other types of innovations, particularly in some of their bottling. So all of these together work to help protect your products and your services. But they are distinct areas of protection and distinct areas of law. And so oftentimes, a person who isn't as familiar with intellectual property, right? This isn't something that you learn about in school. I didn't know what a patent was probably until I was trying to decide to do what I was going to do after chemistry, and I heard about patent law. That's my first memory of learning about a patent. This isn't something that's taught in school at all. This isn't something, I think many people have an idea. They've heard of a copyright. Maybe they've heard of a patent. Maybe they've heard of a trademark. But the concepts of what they actually protect, because we don't have this as part of our formal education, it's a lot fuzzier and start until you start working with it. So hopefully today you leave feeling more confident about what intellectual property is. That's the other thing. Very few people know what the term intellectual property is. Like, what on earth is that? Recently, I was at the Texas Science and Engineering Fair in College Station with high school and middle school students. And I asked the students, do you know about IP? And they said, what is that? Do you know what intellectual property is? Nope. I said, have you ever heard of a patent? Yeah, I've heard that word before. But intellectual property is all of these different types of rights. We call it intellectual property because they're creations of our mind, but they are forms of property. Sarah mentioned you can get a loan. They have value, right? These rights, if you obtain one of these rights, they have a value that's associated with it. And a bank would loan you money if you putting that up as collateral. So we talk about intellectual property as a whole. We talk about all of these different concepts, and hopefully today you learn a little bit about each of them so that you have a better understanding of what you might want to protect if you're launching a business. All right. It's still complicated, right? Both the United States Patent and Trademark Office as well as the World Intellectual Property Office have developed tools that will help you identify your IP. So it kind of some basic questions, some quiz that you can answer. And then it says, well, you likely have, you're not giving details. You're answering kind of like yes, no type questions. And it will tell you, yes, you probably have something that might be worth patenting, or you might have trademarks. You might have something that would be protected by copyright, to help you have some idea of what direction to start, right? Where do you need to go? Do you need to look into first, looking at a trademark? Do you need to look into copyright? Do you need to look into patent? So I encourage you to either grab these from these QR codes, or you could, if you lose that, right, just IP identifier tool. If you type that into a search browser, you should be able to find them. They are not perfect, but they are going to give you an idea of what you might be looking at for your products. Why does this matter, right? Like, I'm going to tell you, the information is dense. Going through the process can be complicated, can be frustrating. So, sometimes I hear, is it worth doing it, right? Is it worth protecting my ideas? Well, your efforts in protecting your intellectual property will allow you to turn those innovative ideas, those creative designs, other things, these intangible, right, things, into something that actually has value, that you can hold, that you can commoditize, right? Whether it is through supporting your own efforts to put a product onto the market, whether it's through business relationships where you are giving somebody a license to your IP and they are the person that is going to bring the product or the services to market, and they're going to send you a check with a percentage of their sales, right? There is value there. So you can't really get a license if you don't have something to license. You can't, if you put your product on the market and it's not protected by intellectual property, there's not much that you can do to stop a competitor to come and bring the same thing onto the market, right, at a slightly lower price point. You're the one who put the time, the effort, the money into developing it, right? And they could then just say, oh, well, it's not protected. I could borrow this and launch it at a lower price point. When you set your price point, you're also recognizing that you've spent time, energy, money to develop it. And without intellectual property, you couldn't stop them. But as Sarah also mentioned, it spurs innovation. Your ideas then it's not just a question of, is a competitor launching another product next week? It's, what do we do with that information at the end of the patent? What does it teach us about the way, the reason we provide for IP protection is that it does actually spur innovation, right? Lisa Cook, this economist that Sarah mentioned, she is phenomenal. I first heard of her. There's a podcast that she did that is talking about IP and patents and the impact of the number of people who are participating in the patent system. Hearing her podcast, I would say I was involved. I did things to talk to the public and about IP and educate about IP. That probably dialed that up several orders of magnitude. So innovation, it can, right? It can cost a lot. We all wonder, why is it when we go to a pharmacy that these medicines that were prescribed by our doctors are so expensive? It's really expensive to develop those pharmaceutical products, right? It's not just a point of necessarily a greedy company that's trying to make money. For every success, there are hundreds and hundreds of failures. That is costly. So, but companies are willing to do it. They are willing to address these problems. And sometimes there's diseases that are a relatively small number of patients, and they're not gonna they're not gonna profit on it. But that helps overall a company support and treat diseases. Right? We think about how many lives have been saved by some of these innovations across the globe. So it's expensive to bring those innovations to market, but if somebody else can steal it and just launch it, right? Nobody would put that money into the innovations. And so by providing for, our founding fathers did think and said, oh, we are going to provide for these protections. We are going to encourage that innovation. And that is all done through the intellectual property law system. All right. So, look, my job is helping people obtain intellectual property. However, I am the first to say that if you're going to put the time, money, energy, effort into obtaining it, it has to make sense to what you're doing for your business. Too many times people think, oh, well, I'm going to get a patent, but it's not really tied into what they're doing from a business standpoint. So when you think about what you're doing, you also want to think, right, what am I doing? What would somebody else do, right? You have to think through that business lens so that the IP makes sense in light of your business and in light of, right, what others might want to do. If it doesn't make sense in the context of your business, it's just really not of quite the value. Now, a bank still may give you some, a loan for it, but if it doesn't help prevent competition, your space in the market, or you can't get the same type of license if you're looking to license it, then it doesn't have the value that it could have had if you always keep in mind the business side of things, not just the technical side of things, but the business side of things. Most businesses don't do the best job of protecting their IP. I mean, there's the whole spectrum, right? But it's always important. I would say the most successful entities that are protecting their IP don't just have the hyper focus on the technology. They also have that perspective of the business, so that they can make the IP matter. And sometimes even companies who are really focused on IP, they don't protect the right stuff, right? And so if you are going into this process, just, you know, ensure that you are, if you are working with a lawyer or you are, talking to somebody, make sure you try to keep not just like, well, what am I doing? What would a competitor do? So that you are thinking kind of from all angles. That's what our job is as lawyers, is to help our clients understand and make sure that what we are doing is worthwhile. Sometimes some of my clients who are really large companies who are very focused on protecting their IP, they're just asking me to do something and I don't get enough business context and I'm going in one direction and they've not given me the rest of the business information. And so maybe that patent that's issued isn't as helpful and isn't as protective as it could have been if I had been involved as kind of a business partner, right? Give your, talk to, if you're hiring a lawyer, talk to them about what your business strategy is so that they can help provide and guide you to allow your IP to protect the right stuff. Some companies are strategic to their IP, not all. That's where this is super critical, and I encourage you, right, if you're going into this process, to try to think strategically. Also, from a cost standpoint, right? It's not cheap to get intellectual property. And so sometimes it's also a question of like, how can we time things? How can we work in a, on a time scale that's based and aligned with, your, business objectives, when you might have, funds available to spend. All of those things are things that are extremely helpful to give that strategy, right? If we can develop a strategy that looks and keeps all of those things in mind, it makes it, one, more feasible for you, and two, more in line with your business. So there is the need for intelligent IP. All right. So why are some of these things important? It's not just right. It's not just the documentation that you get from the government saying that you have the IP, right? It's important to understand as you launch a new product, you have a time clock that starts if you're interested in obtaining a patent, and not just a time clock in the United States. If you're interested in protecting your invention in some countries across the globe, you might be out of luck once that ship, has once you let go of the ship, once that product is launched, you might foreclose some of your rights just based on, a small sale. It was just one. Well, that just one may have prevented you from being able to obtain a patent in Europe, if that's a place that you are interested in. You're launching, your business, you have a product name, a brand name, but you don't actually look to see whether that brand name, whether it's available to protect or whether it might infringe on somebody else's. If a new brand is rolled out and it's not cleared, you might be infringing on somebody's rights. You might have to, one, either rebrand, or two, rebrand and pay some sort of settlement to the other party for infringing their rights. A rebrand as you're launching a product is probably the last thing that you want to do, because you may have first gotten some traction under one brand and now you're having to rebrand, right? A small step up front will help give that clearance so that with certainty that this is an okay process, right? You might have, right, you're having some space or you're talking to somebody and you go into details about what you have a patent, but you go into some details on something that didn't necessarily need to be in the patent, and it's something that you should hold as a trade secret. Once that cat is let out of the bag, right? That secret's gone and you can't hold it as a trade secret. One of my partners talks about a client that he walked into their conference room, and on the wall of the conference room was this framed schematic. And that framed schematic included basically all the company's trade secrets. And everybody who walked into that room, which included, right, potential partners in business, sat in that meeting room and saw everything. And it's like, well, what do you want to talk about? Well, we want to talk about how we can protect our trade secrets. What do we need to do? And it's like, well, step one, never hang them on the wall of this this meeting room, right? So it involves things like ensuring that if you're hiring somebody that, there is confidentiality provisions, that if you are working with a partner, that you are doing so under a NDA, a non-disclosure agreement, or a confidentiality agreement, so that those are steps that are reasonable steps to help keep things as a secret so that you can maintain them as a secret. If somebody violates it, right, there's going to be a clause that says what's going to happen, or then you could have a cause of action against them, right, that you could recover from that misappropriation. So if the trade secrets are on display, they are gone as a trade secret. And then last, assignment. So all of these rights have value. Who owns them? Well, each form of intellectual property is slightly different as it relates to who owns the rights. In the patent context, the inventors are the original owners. And that means that maybe you're working with, somebody, a partner, and y'all are like, well, we're both going to own things. But what happens if that, you part ways? Who owns it then? You both do still. You can both allow somebody to make you sell your patent. So getting your assignments down and understanding ownership. If you are agreeing to any contract, right? If you're signing, sometimes as you're starting out, you're talking to a bigger company, and you need to look at what those terms are, and if something's being developed, who owns it. That's super critical because you might be doing work and don't have the right. So understanding this assignment piece is super critical. So key takeaways. While there are certainly a cost associated with intellectual property, those rights have value. Sometimes, right, I'm being honest here, not 100% of patents are commercialized. You can't look at patents and see, oh, yep, I know that product on the market. Because sometimes, right, we file patents earlier in the system and companies go in a different direction. For large patent filers, large companies who do a lot of patent filings, right, they are going to be proactive, and there might be a lot of patents that they file on, but their business goes in one direction. And a patent is just a piece of the puzzle. It's a big part of the emphasis of the TIPA, the Inventors Patent Academy course. A patent is a piece of the puzzle, right? It's a piece of the plan. It doesn't just, you don't get a patent and then your product is successfully launched on the market, right? If anybody's seen Shark Tank, you can see these entrepreneurs who, many of them at this point do have patents, and they're asked about it, but they are still trying to get their products launched, their businesses launched. And so it's not a one-to-one correlation, right? I always tell clients this because, to put a lot of, work, money, time, energy into something, I want to be transparent and have a client, right, leave the process with a clear understanding of what they have and what they're doing. These different forms of intellectual property, while they all fit under the name intellectual property, they do not all operate the same. And so talking to a lawyer, or if you're talking about a patent agent is a person who is licensed to practice patent law before the United States Patent and Trademark Office. A patent agent can help you obtain a patent, but not all lawyers, right, can help you. If a person, I always tell the people who sit in my class, like, talk to the lawyer, find out whether they know what, your technology is. I'm a chemist. Don't come to me. Like, I am going to say no to somebody who comes to me and says they'd like help with software. I am not the best fit. I am happy to provide alternative names, right? You are interviewing that person to ensure that they can help you and represent you and understand your business objectives, like the technical details, whatnot. So, likewise, I do a little bit on the trademark side. And by a little bit, I mean I work with a colleague who focuses on trademark, and I am present in conversations. And if a client asks me to go into something, I'm going to bring a colleague in who can really help. Like, I don't want to dabble in something, because to me, if I'm dabbling in something, I can't provide the skill and expertise that my client deserves. So if you talk to somebody and they spend a little bit of time doing this and a little bit of time doing this, they might be dabbling, they might be able to help you, but it's also a good idea to talk to multiple people to see, right, is this person really going to help you get you where you want to be? Keep in mind, remember that a single product or service can be protected by all forms of IP rights. And so it's not, it's not just, okay, I have a patent, I'm protected. You also want to think about, trademark. Is there something from a trade secret standpoint that you need to think about? Do you need to think about copyright, etc.? But that most of all, obtaining this IP is what allows you to prevent others from copying your invention, your brand, your creation. So I think we have, if there's a question or two, we can. Uh-huh. You have to have enough that teaches somebody how to make and use. So you don't have to have a working model. Now, in general, I would say, there are certain areas of technology, the more unpredictable something is, you might need to demonstrate results. If you're working in a really highly unpredictable field like biotechnology, you would need to, not everything works, right? And so that's part of whether or not you can really teach somebody how to make and use, is a question of, the area of technology. But for by and large, no, you don't have to have gotten it working. And a lot of entities don't, because to get to that stage, you might need to make a disclosure, and then you're foregoing patent rights. And so it's kind of a question. And that's something, if you are talking to somebody, you can, go into specifics of what's the right time to file. Yes.
Um, Good morning. My name is Angel Bush, and I'm the founder of Black Women in Artificial Intelligence. And so, my question is, where does AI fit in terms of trademarks and patents? Have they landed on a answer to that?
Um, so kind of a complicated answer. Pieces of AI have been protected for many years through intellectual property. On the patent side, right, there's a fair amount on the technical details. What's kind of an evolving question is a question of, if you're using AI, what does that mean with respect to inventorship? An inventor is a person, but a person can use tools. They can use tools in a lab. They can use AI. It's just a question of, how it does. Justin, are you going to talk about AI and copyright at all, or? Okay, so we'll save that answer. The short answer also is artists are people as well, but it's a more complicated. It's a very it's evolving daily, weekly, right? At a very high level, and at a policy level. Obviously, AI is rapidly changing the landscape of technology, and the law is evolving alongside of it, but keeping in mind that uh, generally the core of the right, the IP right, is a person, and that's a human. Hmm. Any other? Yes.
Yes, so for example, AI itself, right, it takes a lot of stuff from the internet.
Uh-huh.
It creates stuff, like stuff to sort of create everything it sits around, right, and create something like new, made of all the stuff that was created before.
Hmm.
So for you, for example, as a company that, for example, has a certain amount of like hard drives and certain images, etc., how can you ensure that you protect your own like stuff from the AI using that stuff, recycling it, and creating something new based on your own method?
There are several lawsuits underway that are artists and copyright holders who have sued some of the AI companies for that issue. And so I would say, we'll see how those cases. I mean, this is right why the law evolves daily, right, in courtrooms everywhere. But this is a piece of it that is currently in our court system right now. Our laws, like our statutes that Congress enacts, they tend to, well, on one hand, right, like from an AI standpoint, like AI is evolving every day, and think about how do we craft laws. So there's a little bit of a like we see how things progress, and then our laws are often written. And so whether there will be laws that are enacted in the future, who knows? Those cases will give guidance with respect to how to best protect, I think, your creations. Yes.
Designer of a component, if I'm using something like an Autodesk product, which is cloud-based, how do I protect myself? I mean, my design is there on their cloud. Is it still protected even though I've basically published it to their cloud?
And so in that instance, it's probably a question of like, is it accessible to other people? So when we talk about from a patent standpoint, is something new? Is it non-obvious? It's based on disclosures of other people, right? Whether it's they've obtained a patent, whether they've written about it, whether they've put a product into the market, whether you've talked about it, right? Is your disclosure, publishing your design onto this cloud platform, considered a disclosure against yourself that could be cited?
Yeah.
And the question is going to be based on public accessibility and whether the public could access it. And it's a little bit more complicated because it's like, is it in a form that's public and can be like indexed and found? And so from a standpoint of how to protect yourself is right. Like if you're publishing something and you're not it's not patented, you want to actually make sure, from a best case that it's not accessed by others. Now, does that mean, is there some, bad actor who hacked into the cloud and got it? Like that is not going to be a disclosure that counts against you, right? If you took steps, you think that it is in a place that's not accessible, that you should be protected.
Right. So from the back end people from
Yeah.
Autodesk who have
Yeah.
access to the cloud, I'm protected because it's there.
Yeah.
Okay. Thank you.
Mm-hmm. And maybe one last, but I think then we're, yep.
You talked about protecting your IP.
Mm-hmm.
How do you do that if it's in compromised internationally outside of the US?
Yeah, so so intellectual property is not just a US concept. I mean, we were, leaders in terms of developing and protecting an IP system. But rights are if you are interested in protecting your rights outside of the United States, there are steps that you would have to do to protect them in those countries. So if you obtain a US patent, it only protects you in the United States. If you want to protect in other jurisdictions, you also have to obtain a patent in those jurisdictions. So that's part of it from a, like, it can get really expensive, right? Now, when I talk to clients, I mean, I would never advocate and suggest that a client file across the globe because that's really expensive. But, we can talk about like where are competitors, where might somebody do it? You could hit, right, like 90% of the market through in some areas like 3 countries. Well, that 90% for 3 countries is much better than getting that last 10%. So, all right. Well, I think we have to move on. So,
Can there be a family tree diagram of like intellectual property depending on what their values are?
wait, repeat that. Sorry.
Can there be a family tree of like a pattern, like a sorting tree, based on what type of property is which and what owns which,
There's a lot. So we're in, millions and millions and millions of patents, trademarks. So I think it would be, there is a lot of information and that could be sorted and processed. And there are certainly tools and databases that can help do that. But that is not within my technical area. So I'm not exactly, maybe. So, all right. All right. Well, thank you very much.